Yes, Your Honor. Case number 524159, matter of Jacobson versus Butterflies Blaise.
Okay. Good morning. I'd like to reserve 2 minutes for rebuttal. If it please the court, my name is Barry Jacobson, and I represent the petitioner in this matter, Matthew Jacobson. Petitioner appears here today to ask this court to annul the respondent's decision dismissing him from school and noting his permanent academic transcript of alleged violations of the Student Conduct Code and New York's Enough is Enough law, codifying Title IX regulations concerning sexual violence, as this decision is not supported by substantial evidence as required, is arbitrary, capricious, and an abuse of discretion because it is irrational and unreasonable, and is further based on a total dearth of any meaningful due process protections. Petitioner submits that this matter presents the perfect storm in that it's not that the respondents got one or two things wrong. They didn't get one thing right, starting with an erroneous interpretation of the governing law, resulting in what is an apparently intentional, misstated, and misdirected definition of affirmative consent that provides the foundation for their erroneous finding. That misstatement comes down to basically the respondent's published policy as found in the record at 152, basically saying we must make verbal consent the cornerstone of affirmative consent. However, that's not what the Enough is Enough law reads. That is not what Title IX affirmative consent definition reads. It clearly states that affirmative consent can be inferred from either actions or words, not actions and words.
Mr. Jacobson, when you look at the conduct in this case as the other component of that standard, what does the record show as to consent for each of the events throughout the evening and in the morning?
What the record shows is two students or two kids who basically don't remember what happened. And as respondents have pointed out, that's because they were, or at least that's the reference I'm getting, that perhaps the young lady involved was incapacitated. And that's not what her conduct or behavior shows. It shows she might have had a few drinks. She might have even been technically intoxicated. We don't know. We'll never know in terms of that. But what it shows is that these two students voluntarily got together and had a sexual rendezvous, not a one-time slam-bang kind of thank you ma'am thing. They were together for 7 hours, during which there were at least 3 acts of sexual intercourse, a number of other sexual acts, some of which, when the petitioner asked the respondent, do you want to do this? She said, no. And no carried the day. Those acts were not consummated. So the bottom line here, based on, again, the summary of the interview of the young lady involved, which we discuss at length in our brief, which is clearly a summary with parenthetical entries trying to direct not so much what KH said, but what respondent Blaise was hoping to take as what KH meant. And throughout that summary, even reviewed in the best light, at no place does the young lady involved say, hey, I didn't want to do that. He made me do that.
Counsel, can hearsay alone form the basis of...
Excuse me?
Can hearsay alone form the basis of substantial evidence?
Judge, I would say to you, if this was even qualifiable hearsay, maybe that question would lie. But as we've submitted in our briefs, it is not qualifiable hearsay. In every case cited by the respondents and by the petitioner, there was an indicia of reliability and credibility of whatever hearsay was used, whether it was subject to the hearsay exception or not subject to the hearsay exception. Why? Because in college disciplinary procedures, it's not unusual to use that kind of evidence. But in all of those cases, there was an underlying criminal action, which means somebody swore or verified something. In this matter, not only is this, quote, statement not signed, not dated, not sworn to, not initialed, not only by KH, but not even by Ms. Blaise herself. And she is not sworn at the college disciplinary hearing. There is nothing here that would indicate any reliability or credibility in whatever was put forward, especially when Ms. Blaise clearly tells us this is a summary. And what is a summary by definition? It means that I have made certain decisions in what's important and what is not important. So we don't even know what she said because she never takes ownership of it. Nobody ever takes ownership of this statement. In fact, there's additional evidence to show that even in their version of the order of protection, nobody ever signs it, nobody ever initials it. There is no proof whatsoever that, quite frankly, that Ms. Hunt, I'm sorry, I'm withdrawn, KH, even knew what was going on after the initial situation, and we don't even know what her involvement was in the initial situation.
Sir, you have a limited amount of time, so if you have other points you want to cover.
Thank you, Judge. The point is, Judge, Your Honors, that any one of these failures in itself might very well lead a court to conclude that there was no substantial evidence, etc. But our point here is only if you read the requirement of verbal consent is there any possible logical underpinning to this decision. Because respondents themselves say in their argument before the Supreme Court, this was an admission. It was an admission if we accept that the petitioner never said, I received verbal consent, which he never did. He doesn't remember. Nobody remembers.
Counselor, could I just take you to the hearing for a moment?
Yes.
Is this the evidence that, I'm trying to, and I think it's in the record from 166 to 185, that what was in evidence was an investigative report, including summaries of Ms. Blaise's interviews,
Right.
factual findings, conclusions of law, and is that all the evidence that,
That was it, with one witness and one witness only.
and maybe this is better asked to your opponent, but I think I'm used to preparing findings of fact and conclusions of law subsequent to a hearing. How do we have findings of fact and conclusions of law submitted as evidence in a hearing?
Because, Judge, I think you just hit the nail on the head. As we've said in our submissions, Respondent Blaise was the complainant, was the witness, was the prosecutor, prepared the evidence package, presented the case, but went further, much further than that. If you read the transcript, which is in evidence, she was making rulings on admissibility of questions. She was in effect, if you want to think of the board as the jury, she was charging them on what they had to do. Certainly, it's not unreasonable then that she could present the findings of fact and conclusions of law beforehand, because in fact, she was the hearing. And that's the problem with the due process also. From respondents' point of view, what they did is due process.
And if you know, who, assuming the judicial pool that
That the board is selected from?
is trained,
As far,
who trains them?
Judge, as far as I know, as the Title IX coordinator, she is responsible for selection, training, etc. How much of that, I mean, whether or not Mr. Allen, Respondent Allen, who was the alleged chairman of this board has, I can't tell you. But certainly, she had a sway of influence that would not be proper. And as respondents pointed out in their answer, we alleged bias but couldn't prove it. It's not, they misunderstand what we mean by bias. This is an appearance of impropriety, an appearance of bias. When you're playing all the roles and changing roles as you're going along, musical hats, musical chairs, that is our point, that this was a fait accompli. This hearing was just a show trial, so to speak. I don't know how I'm doing on time, but I'm reserving the 2 minutes. I think I can say one more thing. In terms of the juxtaposition of all of the procedural, of the substantive failures, as enhanced by the procedural failures, in that we could not have addressed these issues at an earlier juncture because the respondents' policies and procedures don't allow it. They've made subsequent changes in their later student conduct codes that addresses some of these. Now, whether they're meaningful and real or simply lipstick on a pig is a little bit too early to know, as if we're going to know, because remember, what has transpired since these cases were filed is that the federal government has withdrawn substantial portions of the Title IX requirements and guidelines.
What effect does that have on this case?
Judge, I don't know that it has any direct effect unless this court decides that it has retroactive effect to all those concerned, but it's a clear indication that the people who created these guidelines see a problem with it. Ms. DeVos, the Secretary of the Department of Education, when she issued these withdrawals, basically said that this was a reactionary response by the colleges, basically denying students due process, and that no student should have to sue to get due process. In effect, what happened is when these regulations were created, they were guidelines. No college was told exactly how to apply them. In fact, looking through both the state university and the private universities, they all have their own ways of applying it. The problem is that they were never given any definitive instructions about what constitutes minimum due process, so they went off on their own. And that really was why that eventually the federal government had to step in, not only in New York, but throughout the country, to say there is an issue here. Because let us also remember, it is the colleges themselves, the respondents themselves, that caused the need for these guidelines in their persistent ignorance of legitimate claims of sexual abuse by females for the purposes of protecting their reputation and their bottom line.
Counsel, when can I take you to a different place for a second? The investigative report was a piece of evidence, wasn't it?
As used by them, it
Yes.
was a piece of evidence.
Right.
Yes.
I'm using it generically. And when did you receive that?
We did not, anything that was in that evidence packet that was presented at the hearing, as we have said in our brief, when we appeared at that hearing, we were told we could look at it, but they didn't have enough copies to let us have one at that time. So we took a quick glance at it. The proceeding took place. We didn't have it in our possession. We didn't get that until after the hearing was over. We didn't get anything.
So doesn't the handbook require that that be delivered to you prior to the hearing?
No, it does not, actually, at least not in the original, in the version covering the 2015-2016, to my knowledge.
I
it
thought
did not.
upon request.
Well, that's
You were
another
at the-
interesting thing. When I spoke as the attorney to Respondent Allen, and he said, and this was a week before, because remember, the time constraints and the limited time from the time the petitioner was notified that he was being charged with specific specifications to the time the hearing was held, we were told he can obtain that from the complainant. I submit to you, he knew full well that we at that point believed the complainant was the young lady involved. And my answer to him was, I think since you have an order of protection, it would be kind of foolish for the petitioner to ask the complainant to turn over these items. So no, there was no attempt to clarify that. I think I'm out of time in terms of reserving the 2 minutes I wanted to do it. if that's okay.
Thank you.
Your Honors.
Mr. Palladino, there was a lot of questions. Your adversary had additional time. You have it as well if you need it or want it.
Thank you, Your Honor. I'll begin by giving my answer to Justice Pritzker's question. Yes, hearsay can constitute substantial evidence. Here we have a detailed hearsay statement, the statement that the Title IX coordinator took from the reporting individual, and it bears indicia of reliability, and it can constitute substantial evidence. What it says is that KH does not recall how the intercourse was initiated, and she wakes up to the petitioner having sex with her. She then describes how she blacks in and out of consciousness. That is certainly substantial evidence to support the determination that KH was so intoxicated that she was not capable of giving consent through her conduct. There's no dispute that there was no verbal consent here. It's essentially.
Didn't she deny being intoxicated, though?
Oh, not at all. She testified to having 3, 4, or maybe more 25-ounce twisted teas, each of which is 5% alcohol. That's a tremendous amount of alcohol. And her statement is essentially the same with respect to the second incident. She blacks in and out of consciousness. She wakes up, they're having sex again. And on that, petitioner's own testimony provided support for the conclusion that there was no affirmative consent with respect to the second sexual encounter. His testimony, when he was asked, well, what made you think you had consent the second time, was essentially to say we had sex the first time. In his own words, it was just a continuation from the first time. He doesn't point to any words or conduct.
Well, it was a continuation, though, wasn't it? I mean, he didn't, leave the room and then, come back in at some point, or it was a continuation, wasn't it?
Yes, there had been an earlier sexual encounter where, according to KH, she's waking up to having sex with the petitioner. She essentially gives the same statement with respect to the second time.
Did she let him in, open the door? Wasn't there a door that she met him at? She wasn't,
yes.
So
Yeah,
she was
yes.
not intoxicated that much to let him in, I guess? Or?
Yes, I mean, but there was testimony even by the petitioner. She's stumbling around. Certainly, she does certain things, inviting him into her room and making out with him and that sort of thing, that shows consent to doing something, but not when you're blacking out to having sex several times. And
Mr. Palladino, you're picking parts of the statement. Don't we have to look at the whole statement, though? Because what we're looking at is a statute that provides that there's a presumption that the respondent is not responsible until there's a preponderance of the evidence to show that there was an absence of consent. So in looking at the consent question, don't we have to look at the full statement to define the event itself as to what occurred between these two?
Oh, I completely agree, Justice Lynch, and I trust that the court will read KH's statement in full. I do not want to stand here and read for 5 minutes. I'm highlighting what I claim to be the key points. What you have is-
May I go to Judge Lynch's comment, just take it a little bit further? Nobody says that there was verbal consent. And so if nobody says that, and then the finding is there's no consent, nobody ever considered consent by conduct.
I would disagree, Your Honor.
Why would they? There's no consent. There's no oral consent. So we can't even know, because the wrong standard was given by the prosecutor, by the trainer of the judicial pool, who's trained the pool. The wrong definition was given. So why would you, if nobody's saying there was verbal consent, why would you even get to consent by conduct? And we can't even know if it was considered.
What Your Honor is referring to is the statement that the Title IX coordinator made. Let's put it in context. After she reads the two statements, and after the petitioner testifies, there's questioning. He asks her what constitutes consent. What he doesn't mention is she first reads word for word the code, which clearly says that words or conduct can suffice. She's then asked, well, then can conduct suffice? She gives an admittedly confusing answer, and I'll assume for purposes of discussion, it says essentially you need
It's pretty
work.
definitive, wasn't it?
There's no objection made to that, there's no follow-up inquiry. So what you have is the board, I think, is presumed to understand the code. To the extent it's unclear, that's because of a failure to object. But if Your Honor is troubled and thinks that it might have tainted it, the remedy isn't annulment, it's you send it back, we say, for a more detailed statement by the hearing board. They can explain whether or not they were misled, or alternatively,
Well,
a
Mr.
new hearing.
Mr. Palladino, if I may interrupt on that precise point as to the remedy. What Judge Devine just has focused on is that question during the hearing by the respondent. And the question was, so affirmative consent can be implied or referred from conduct? Answer, only if the direct question is with the specific. And the focus is clearly on verbal. I would think that that would have affected the balance of the hearing itself. So if this standard somehow compromised the decision, wouldn't the remedy necessarily be to have a new hearing?
Not necessarily, that could be, it's one of two things. It's either, let's have the board explain itself and see whether it was misled, because we really can't tell.
Well,
from this
I don't
record.
think it's just the board at this point. I think it's also the respondent as to the continuation of this proceeding, isn't it?
Well, the Title IX coordinator, despite what my opponent says, is not the judge and the jury. It's true that Ms. Blaise is the investigator, she presents the case, and she acts as a witness. The judge is Larry Allen, the director of student conduct, and the jury, so to speak, is the board. And really the question is what Ms. Blaise said in response to the petitioner's question assumed to have influenced and tainted their determination? We know they were read the correct definition of the code, and if you apply the presumption of regularity in the absence of any indication that they misapplied it, you can affirm. But if you do not agree with that, if you're troubled, like I said, you can either ask the board to explain, were you misled or not, or you could order a new hearing. Either one would be satisfactory. But the suggestion that just because the Title IX coordinator makes a mistake, the whole thing has to be annulled, just doesn't follow.
There's another part of the hearing, if I may ask about. The respondent asked if he could present questions to the reporting individual. And the answer was no. We now have the withdrawal of the federal administrative guidance. And one of the things I noticed in the statute itself, when it defines reporting individual, it defines that person to encompass terms including victim and complainant. If you have a hearing in which the respondent has asked, can I present some questions? There are other cases where questions are considered by the complainant, if you will, whether or not those will be presented to the reporting individual. Here, it was a flat-out no. Does that comply with a minimal due process as necessary under the statute?
Well, yes, Your Honor. The reporting individual, like I said, indicated that she did not want to participate. And this is the problem, and this is why I don't envy you your job, is that SUNY doesn't have the authority to compel her to testify. It may very well be that the reporting individual would consent to being questioned or to have questions posed to her. We don't know that since that specific request wasn't made. We had an inquiry by the petitioner, can he confront and cross-examine her, and they were told no.
I think the question was more, may I ask questions? And the concept of an alternative mechanism to do that doesn't appear in this record. And certainly the reporting individual has every right not to participate. But at the same time, is there some necessary minimum due process component that would allow the respondent to at least propose questions to be considered?
The Sixth Circuit would say yes to that, and had that been proposed, we don't know what would have happened. What we do know is the reporting individual said she didn't want to participate. Let's just assume would have said no to, can we ask you questions from petitioner filtered through us? The question becomes, what happens? Do the charges have to be dismissed? What we say is that the board certainly could take her sort of refusal to answer questions into account in determining whether or not the charges had been proven. Or it can say, as it evidently did here, that we have such a detailed statement that was given to the Title IX coordinator that, at least with respect to the second sexual encounter, is corroborated by the petitioner. And although it would certainly be ideal and helpful and preferable if we could talk to her, but she's not willing and we can't make her, they can conclude we still have enough to make a determination of this matter.
Does that accord the respondent the necessary minimal due process as required under the statute?
Yes, it does. I mean, I understand why he wants to ask her certain questions, but if we can't make her, and there is a legitimate interest in not forcing someone who might have been the victim of sexual assault to testify, the hearing panel has before it ample evidence. It can reach a conclusion as to the charges in this case. I mean, the other conclusion is that if she doesn't want to participate, you have to dismiss the charges. So what you're effectively doing is compelling her to participate in the hearing.
Well, let me ask
That's
you a
the
question
trouble.
about participation. She was present on Skype, correct?
Yes, Your Honor.
And forgive my lack of knowledge on Skype, but I thought Skype was a two-way street.
It may very well be that there was the technology where they could have questioned her. And this is what's unclear is.
So how does that play into whether she did I mean, can you partially participate? Well, this whole due process question is very, very troublesome, as it's obvious, I think, from the questions. But so now you can partially participate, and the boy is unable to even submit questions that someone else could ask her in a decent way. But the reporting individual gets to watch and listen and do everything and partially participate. That's sort of not fair either, is it?
When I say she participated, she's watching.
Well, yes, that's my question to you. Is you define that as not participating at all or partially participating?
Well, whatever label you put on it, what really this boils down to is obviously he wants to ask questions of her. That request wasn't made. If she, let's say, says no, I don't want to, what you have to decide is, does due process mandate the dismissal of the charges? I say no, because if they have adequate evidence before them, they can either say, they can find the person responsible, or they can say, I'm taking into account the fact that she is trying to have it both ways and is not willing to participate, and we think that you don't meet your burden. I think that's within the discretion of the hearing board.
Nothing.
Pardon me,
That
Your Honor?
that didn't happen, right? We don't know that they took that into.
That's correct, because there was this colloquy that we're all referring to, where he wants to question her, and they say she's not participating. There was not the, well, can you at least go talk to her? That's what the Sixth Circuit is suggesting. That particular claim really isn't preserved, and what we're talking about is, what if that had actually happened? I think that would be a desirable procedure going forward, but in this case, that was not pursued, and really the question becomes, what do you do?
Well, what about the changes to the handbook subsequent?
I'm not aware of the specific changes to which counsel is referring.
I've got the record pages, page 700 to 717, and I think there were numerous changes to the handbook that were precipitated by an email saying this procedure might not have been that great, so changes were made to the handbook. Wouldn't that in and of itself tell you there were problems with the proceeding? Maybe the administrative appeal should have been granted.
What I take from that is that SUNY is always trying to improve the process, both how it's organized generally and its implementation. There's no concession here of anything that occurred that mandates the annulment. We do acknowledge that there's some uncertainty as to whether the board was, swayed by Blaise's misstatement. We don't think we think the presumption should be that they applied the code that was read to them, but if you don't agree, like I said, there should be either a do-over or a new hearing. But this claim, I wanted to address this claim that's made that because Blaise.
Why should there be a presumption that they applied the code as read at the expense of ignoring what she said in her verbal comments after being asked a question?
Because witnesses do make mistakes and make misstatements. The code, it could have been pointed out to the board. Doesn't the code that you just read say that conduct is enough? There's a presumption of regularity that the board that was trained knew and understood the code that was read to it. But again, I don't want to repeat myself.
Who trained the board?
It is in part the Title IX coordinator.
So the person that made the same statement trained the board?
Again, we don't know. I don't think that there's any evidence that she intentionally made this misstatement.
It's not relevant whether
It's not,
intentional.
well, it is because what the petitioner's trying to do is say, she made that statement on purpose, and therefore you can't trust her to have accurately recorded KH's statement. And that just doesn't follow. I mean, there's no proof that the statement was intentional. And the only evidence in the record concerning the accuracy of that statement is found in page 539, where she says, it's in KH's own words. And if you look at the statement itself, it's written in the first person. There are quotation marks used. There are brackets where the Title IX coordinator is making clear, okay, now I'm asking her about the first incident, the second incident, and so on. And this was a subject about which the petitioner could have questioned the Title IX coordinator to determine the extent to which it was edited or summarized and that sort of thing. But given the only evidence being that it's in her own words and you read it on its face, it is adequate to support the charges. Now,
Doesn't this get more, I'm sorry to interrupt, but doesn't this get more complicated because the actual investigative report was only provided at the start of the hearing?
There's really no evidence of that. The rules required that the petitioner be given it 24 hours in advance. There really isn't, the record is sort of somewhat silent on that, and we can't have counsel testifying at the podium here.
But the record indicates that a certain number of, I think the record indicates a certain number of copies were brought to the proceeding, but not enough. Mm-hmm. And so doesn't that indicate, can we rely upon that to demonstrate that the actual copies were not available to the respondent until the hearing itself?
It doesn't necessarily follow. It's unclear. That's, again, another matter about which an inadequate record was made. There was no allegation that had I had that earlier, I would have presented a different witness or a different document. This was essentially a he said, she said situation. The petitioner knew what the allegations were against him. He was allowed to present his case. He argued about his conduct. He's not suggesting, oh, had I had this earlier, I would have taken a different tact.
It's he said, she said, but she didn't testify. He testified with a presumption.
The courts of this state have routinely allowed hearsay to form the basis of very important determinations, like doctors can lose their license based on hearsay. And this statement does have reliability, indicia of reliability. It's detail, the extent to which it matches what the petitioner says in many respects.
Mr. Palladino, can I, I'm sorry,
Sure.
we don't have a lot of time, I know, and I want to ask this question. Under the statute, the decision is supposed to be detailed findings for both the decision itself and for the rationale for the sanction. Do you find compliance with that requirement in the actual letter decision, the May 11th decision of this, Mr. Allen?
Well, rather than my characterizing it, well, I'll tell you what it says. It essentially says, we find by preponderance of the evidence that the petitioner had sex with KH 3 times without her affirmative consent.
It appears to be a restatement of the charge.
If this court finds that that is inadequate, the remedy is under this court's decision is in Boyd, is send it back for a more detailed statement. Perhaps that would also allow for clarification of whether the board was swayed by the Title IX coordinator's misstatement about the code of conduct. So that's what this case is pointing to, that because there's obviously adequate evidence to support the charges, there's no reason for expungement. I just want to address the reliability of hearsay. I mean, this court has repeatedly upheld the authority of an administrative agency to overturn an ALJ's credibility determinations and to make his own credibility determinations, even though the head of the agency hasn't personally interviewed the witnesses or assessed their demeanor. So obviously, an administrative determination, including credibility determinations, can be made simply by reading hearsay statements. I mean, you have to look no further than the Court of Appeals decision in Abdur Rahim versus Mann, where the Court of Appeals upheld the practice of a hearing officer assessing the credibility of a confidential informant, even without talking to the confidential informant.
These are hearsay statements that are being proffered by a Title IX coordinator who has some sway with this group as well. So isn't it getting multiplied, the credibility getting multiplied by her presentation?
I would disagree with that, Your Honor. I mean, that goes to, obviously, are you changing what she said? That's a subject about which the petitioner could have inquired. Look at the statement itself. It is written in the first person. It is detailed.
The fact that she's reading it is vouching for it, isn't it?
Again, certainly that is an argument that the petitioner has made. It's up to the hearing panel to decide whether or not they believe it or not. I mean, you have she said hearsay versus petitioner's live testimony. That is a question of credibility. The only time it would be improper to rely on the hearsay would be two instances. Either the hearsay is totally conclusory, like if KH had simply said, I was raped, and that's all she said, or if on the other side, the petitioner submitted evidence so overwhelming that no reasonable person could have credited the hearsay. If he had a videotape, let's say, of the encounter, it might have not been rational to credit the hearsay statement. But that wasn't presented here. We have a detailed statement by her, admittedly related to the Title IX coordinator, versus his live testimony. The hearing panel was entitled to credit her statement. But again, I know the court is troubled about certain aspects of this, how this hearing went down. Send it back either for a new decision or a new hearing.
Thank you.
Thank you.
Thank you. This court doesn't need me to go over what's in the voluminous record or explain to them. They can do that well without my suggestions. However, I would like to just answer a few points. One being the issue of the remand. First of all, at this point, to remand this, we don't even know, the court doesn't know whether or not the person who allegedly provided this information is still even a student there. But that's a whole other issue. These issues arose because of respondent's failure. After interfering with the petitioner's life for a year, now we say to him, let's start us all over again. Give us another chance because of our errors. And what bothers me most about the respondent's position about an unpreserved claim of due process, let's take a quick look at that. What is respondent saying here? Respondent has asked this court to give it a certain leeway and a certain degree of deference and respect their decisions, yet at the same time points out constantly, we are not a court of law. We are not required to follow the formal regulations or what you would expect out of a court of law. But yet, let us expect from a 19-year-old, from a juvenile, from someone who is uneducated in the law, let us expect from him that he's going to know the difference of when to raise objections. Perhaps maybe he should raise exceptions if those objections were denied. That he should use certain words. He did raise due process. He didn't use the words due process, but he used words that indicated his due process was being violated. Even if we point to the fact that he did have an attorney advising him, the attorney has a very limited role. He cannot speak, he cannot address. All he can do is whisper to his client. And as the hearing transcript showed us, even the request of 15 minutes to discuss this was denied and reduced to 10. So how could any attorney, even Perry Mason for that matter, have made a difference when you are under those kind of restrictions? What bothers me personally most is that a university of higher education should come before this court, the public, or anyone and say, treat us in this manner, but allow us to treat your students, your children, in another manner, and expect from them things that is not expected from us. There were was raised by Judge Lynch and Judge Devine in terms of certain issues of due process and of what happened. I believe what happened does in fact indicate what we have stated, that in fact everything was institutionally directed to prevent any possible direct confrontation. As Justice Lynch said, this was one way. As Justice Devine said, isn't Skype two ways? Yes. How could he have asked for an alternative mechanism of not only examining KH, but more important, as the case law has said, for the trier of fact, the board, to observe the demeanor and the credibility of KH? They couldn't. This was designed as a one-way closed-circuit transmission. There was no way to address these issues because they didn't allow for such a way. And to say that at that point the petitioner should have come up with all these brilliant legal arguments to say, why can't I do this, why can't I do that, is absurd. It's literally throwing salt in the wound. I would submit to the court that whether or not you wish to consider this evidence legitimate, credible hearsay is certainly your prerogative. We, of course, submit that based on its tenuousness and the fact that it was written allegedly in the first person, all the board needs to look at is petitioner's statement. Why wasn't his written in the first person? Why was his written in the third person? If, in fact, Respondent Blaise was doing a lot more than investigating, but was creating or fabricating in the sense of putting those parenthetical explanations. So I submit to you that's not one issue here. It's all of these issues combined that create a cumulative effect, and the totality of the circumstances demand that this case be annulled and a message sent to the respondents that you can't do this.
Thank you both.
Thank you.
All rise. This court is now adjourned until Monday, November 13th at 1:00 p.m.